Welcome back to the High Court Report. I come to you today for a six-pack of takeaways from the Trump versus Slaughter oral arguments. Subscribe, rate, and share for ongoing Supreme Court coverage. Find us on Apple, Spotify, YouTube, and LinkedIn. Subscribe on YouTube for shorts and additional analysis. Here's the six-pack of takeaways. First, Chief Justice Roberts asked an unusually large number of questions, which probably revealed his leanings. He asked the Solicitor General, SG, several questions about workability, how to structure the outcome if the court ruled in President Trump's favor. Conversely, he threw penetrating darts at Slaughter's counsel about the quality of the precedents supporting their position. Second, Justice Sotomayor mounted the strongest defense of a prior case, see below, Humphrey's executor, repeatedly pressing General Sauer on stare decisis. She emphasized that Humphrey stood for 90 years and questioned what other constitutional cases the court overturned with such a long pedigree. Her questions suggested strong resistance to overruling established precedent. Third, the court will probably rule 6-3 in the president's favor. I'm not breaking any news. The court already showed their cards this summer through emergency docket orders. Here's the path they'll likely follow. The court will first find that the Constitution gives the president near unbound power to fire executive employees who hold authority. The court will second find that modern FTC commissioners wield substantial executive authority by filing lawsuits, binding orders, and issuing regulations. The court will third distinguish and overrule Humphrey's executor, a 1935 Supreme Court case that upheld the for-cause removal protections at issue here. Fourth, if the court rules in President Trump's favor, we'll see whose predictions prove true. Slaughter's counsel argued that upholding Slaughter's firing will upend nearly a century of regulatory stability, undermine business planning, and politicize expert decision-making across dozens of federal agencies. The SG rebutted that the sky did not fall when the court removed similar restrictions from other agencies. Fifth, the most devastating moments in Supreme Court arguments happen when justices spot a thread and pull until they unravel the case, and that's exactly what happened in Trump versus Slaughter. Justice Gorsuch began with seemingly simple questions about the president's duty under Article 2. You agree that the president must faithfully execute all the laws? Slaughter's counsel answered, yes. All the laws? Gorsuch pressed. Then came the fatal response. I would say no. Gorsuch then zeroed in. No? Why? The justices recognized they found a clear path to uphold the removal. Article 2 commands the president shall take care that the laws be faithfully executed. The text uses mandatory language, shall, with comprehensive scope. The laws that not some laws, Justice Gorsuch kept pulling the thread. Does he have a duty to faithfully execute all the laws? The answer is no. Why? Then came the knockout punch. Gorsuch exposed the arbitrary distinction between criminal and civil enforcement. So if the government wants to bring a misdemeanor, that person must report to the president. But if the government wants to bring ruinous fines and penalties and injunctions, that person doesn't. At this point, the constitutional logic became inescapable. The president must ensure faithful execution of all laws. Independent agencies enforce consumer protection laws, antitrust laws, labor laws. The president bears constitutional responsibility for laws he cannot control. Removal power enables constitutional compliance. The justices exposed an impossible contradiction. Slaughter's position requires the president to answer for ruinous fines and penalties that he cannot supervise, which would make him unable to faithfully execute the laws. 6. the justices hammered at another point. If Congress can protect FTC commissioners from presidential removal, what stops Congress from restructuring the defense debt as a commission with commissioners removable only for cause? Justice Kavanaugh pressed, could Congress convert all these departments, Commerce, EPA, Homeland Security, State, into multi-member commissions and make them removable only for cause? Slaughter's counsel couldn't explain why the FTC setup represents a constitutional limit rather than a dangerous precedent. The justices recognized that accepting Slaughter's argument would invite Congress to insulate cabinet heads from presidential control, fundamentally destroying executive unity. Sometimes oral arguments matter, sometimes they don't. In this case, the justices used oral arguments to create compass they'll use. In earlier podcast episodes, we compared whether the oral arguments foreshadowed how the justices would rule. Oral arguments emphatically did. Through yesterday's oral arguments, the justices revealed the likely outcome. And a bonus seventh takeaway, Trump versus United States, the Trump special counsel immunity case, made an appearance in Trump versus Slaughter. The Trump immunity case reinforced that some presidential powers are conclusive and preclusive, meaning Congress cannot act on these subjects and courts cannot examine them. In the Trump immunity case, the court identified three clear examples. First, the pardon power. The Constitution grants this exclusively to the president, and Congress cannot limit its effect. Second, removal of executive officers. The president's power to fire those who wield executive power flows directly from Article 2. Third, foreign recognition. Only the president decides which countries America recognizes diplomatically. But here's what makes this framework explosive. The court said these powers create absolute immunity from criminal prosecution because prosecuting the president for exercising exclusive constitutional authority would violate separation of powers. Fast forward to Slaughter. Both sides weaponized this conclusive and preclusive language. Trump's team argued, if removal power is conclusive and preclusive, then Congress cannot restrict it through for-cause removal statutes, period. Slaughter's team countered, only certain officers exercise conclusive and preclusive authority. FTC commissioners don't handle foreign recognition or pardons. They regulate businesses using congressionally delegated power. But Justice Gorsuch exposed the flaw. So criminal prosecutions require presidential control, but ruinous civil fines don't? The Trump versus United States framework created a test neither side could consistently apply. In Trump versus United States, what started as immunity doctrine became the blueprint for restructuring federal power. That's it for today's episode. Thanks for listening to the High Court Report. Please follow, rate, and share the podcast. And connect with us on LinkedIn at the High Court Report for ongoing coverage of this transformational case. Talk to you soon.